You've heard a lot today about the people who've been instrumental in really founding and conceptualizing technology law at the University of Ottawa. I'm talking about Michael Geist and Ian Kerr in particular. I think it's also really important to acknowledge the support that we've had from the Faculty of Law, from deans who have been instrumental in supporting our program. Bruce Feldhusen, Natalie DeRosier, Adam Dodek, and of course, Kristen Boone. It's really important. You've heard about the originators of CLTS, and you've heard about the planning committee. One of the things that makes CLTS so special is the literal rainforest of faculty members contributing expertise to the program. And I know that you've heard about the number of faculty members, but I think it's important to acknowledge and name Wolfgang Alschner and Jen Chandler, Paul Daly, Vanessa Grubin, Elizabeth Judge, Matt Malone, Jenna McGill, Chidi Oguamenom, Mike Powell, Amy Salzin, Doug Sorrow, Teresa Scassa, Marcelo Thompson. I feel like it's an Oscars list here of people to thank for creating such a rich intellectual environment in which all our careers can thrive. That's just the faculty members at the common law section. We've also got Céline Castet-Renard, Karen Eltis, and Mistral Goudreau in the civil law section, not to mention everybody else at the University of Ottawa who makes CLTS thrive. Kelly Bronson, Elizabeth Dubois, Jason Miller, Val Steves, David Murakami Wood, Thomas Mboa, Pajendu Yanchari, and others that make this literally the best place, not just in Canada, but in the world, to do technology, law, and society. And so that's really cool. From there, I wanted to segue, thank you very much, and I wanted to provide that broader context as a way of introducing this panel of really phenomenal private practitioners in the field of law. We've assembled an all-star cast of people who were involved in the early days of the law and technology program to recent graduates. So Dr. Alex Cameron is going to be our moderator, and he'll facilitate a conversation with Mika Ellis, Sarah Cheyenne, Chantay Degans, and Tracy Doyle. So over to you, Alex.
Thank you, Jeremy. It is a real honor to be here. The nostalgia is hitting pretty hard for me, I'll say. It's been a long time since I've been back here and seen many faces in the room. And it's amazing also to meet the many generations that have followed, because at least in what I've heard so far, I am very much an OG here. There are a few others. I know Jason, certainly in my year as well. Milana was in the same period, and others that were there. So we're going to talk a little bit on that nostalgia trip, when we were here, what the hot issues were at the time, which is sort of funny to think about today a little bit, and what we're doing today. So very briefly, I started here in 2003. I won't say when I graduated. Let's just say it was a long time after that. And the biggest issue at that time, as a few have talked about with me today, was music file sharing, which seems very quaint and funny to think about now, but that was the big hot topic during those days when I was here. These days, I work in private practice at Fasken. I work in privacy and cybersecurity and do all things in that domain, from advisory to litigation work. So that's me in a nutshell, but it's not about me. It's mostly this amazing panel that we have here. So all about you guys.
Awesome. Thanks so much for that, Alex. And I just saw a picture of Alex and Jeremy about 25 years ago. It was pretty awesome. Anyway, so first, I'd just like to say that the CLTS has the absolutely most amazing profs. We just heard the Oscar list as Jeremy put out there. And the profs have cultivated and continue to cultivate crops and crops of professionals who are incredibly kind and intelligent and generous with their time. And a lot of the reason why we feel generous with our time is because you guys are so amazing and generous with your time. And we have a drive to pay it forward as well. So my time at the CLTS, I was influenced by so many of you guys in this room right now, but dear Ian Kerr, and Professor De Beer asked, I was in their 1L class, and they said you should sign up for the first year tech law ship. And I don't know why they said that. It's like the first 2 weeks of school. I'm this shy kid who have no idea why I'm in law, actually, and had no technology experience at all. And in fact, in my cover letter, I wrote, I don't know anything about technology. And to Professor Kerr's demise, De Beer got me, and which is to my thrilling, my career has been based off of my work with Jeremy De Beer and Chidi Ogwamnam. And I got to work on a lot of hot topics looking through the lens of Africa. So I worked on Open African Innovation Research and Training with Jeremy De Beer and Chidi Ogwamnam and a bunch of African universities. And we looked at innovation hubs was my area of study. And a plethora of other really cool technology things. And the other area that I got to study, I did later in my 3L, get to study with Professor Kerr, nanorobotics and the healthcare system. So, I mean, those are all emerging even more so now and really interesting topics. Currently what am I doing now? I practice in intellectual property with an emphasis on Indigenous knowledge, cultural expressions. I also work with trademarks and copyrights, so very cool areas of law. I started in a medium-sized firm. It merged to a big firm. That was not for me. I'm now in a 3-person agency and rocking it.
I'm Tracy Doyle. I had a very similar experience to Mika. So I graduated University of Ottawa Law School in 2016. I had kind of the reverse, where I applied for the RA-ship and Professor Kerr got me and not Professor De Beer. And so I had the pleasure of working with him for my first term. And then from there on in, everything was about Jeremy. No, I did a lot of work for him. And a way that he largely influenced me was through litigation, particularly intellectual property litigation. And that is sort of where my path was carved out. What am I doing now? So I was on Bay Street for a number of years, practicing IP litigation, and then my wife is from here, and so she desperately wanted to come back to Ottawa, and we figured out a way to make that work, and that basically meant that I was opening my own firm. So now I have my own firm, and I practice a whole bunch of different areas of law, including intellectual property, but also class actions, Aboriginal law, medical malpractice, general torts, all that stuff. And it is an absolute blast. And I also have the privilege currently of teaching first-year property law at the University of Ottawa. So literally everything has come full circle, and it is great. And what was a hot topic issue when I was in law school, and that in my mind was the promise doctrine in patent law. And that has now been settled to my delight in 67 paragraphs by Justice Rowe. Yes, and onwards.
Hi, everyone. I'm Shantae DeGans. I will start off with my year. I was 2023 graduate, University of Ottawa. And I recall in I think for the COVID era of law school, I took global tech law and policy with Professor Michael Geis, and we talked about vaccines and the privacy implications of kind of sharing open data of who's vaccinated and who's not. And I know that's something that's very topical, I think, when we went to school and being in the pandemic. And that always was very memorable. And then as well, a topic was with Professor Marina Pavlovich and a lot of the media law changes and mock CRTC hearing, Bill C-11. And that was something that's, I think, even trickled into my current practice today. So those are the two biggest things that I recall. And I currently work at Airden Burles in Toronto. I'm in the corporate commercial group. I'm also part of the privacy and security group at the firm and the technology group. So I do a mixture of private M&A and then some technology law work in the commercial drafting sense and regulatory stuff. So that's a bit about me.
My name's Sarah Cheyenne. I started here 10 years ago. I graduated in 2018. The big hot button issues when I started law school and that kind of motivated me to go to law school was around private sector access to public sector data. So the Snowden leaks and sort of relating things around Bill C-51 got me very interested in law school. And then the hot button issue while I was a student was privacy regulation. So I was here, of course, when the General Data Protection Regulation was coming kind of down the pipe, and organizations were trying to figure out how to implement that and what that was going to look like both in Europe and then Canada, United States. My practice now, I'm at Stikeman Elliott in Toronto. I have been there for 6 years, and my practice is primarily it's a little bit of corporate commercial work. It's a lot of technology contracting, a little bit of transaction support, so organizations purchasing entities or divesting entities, and then a little bit of privacy advisory work as well.
Amazing. A theme here in how we were, enticed into this with, amazing people, amazing issues to grapple with. Since we talked about Jeremy DeBeer a couple of times, I do want to put a plug in for Ian Kerr as well. And Michael sort of got me here. Ian and many others kept me here for a long time. And really it is very, very inspiring. On a somewhat lighter note, we will get to the very important issues about how lawyers in private practice are shaping technology, but I thought it might be fun to talk for a minute about, from our panel, how lawyers in private practice use technology and whether we're any good at that, whether we have any notable successes, failures, anything technology shaping your practice as opposed to the reverse as a starting point.
I wrote down a ton of examples because I wanted to preface this with being the new grad. I think on most teams I'm on, I'm looked to as, well, you know how to use this software we pay for. And I'm told by partners, I'm like, I've added you to the Diligent account. And they're like, I don't know what that is, but it sounds like you know what you're doing. So those are just like little anecdotes. So I think technology is used across, I think, business law firms and different practice groups. So in my M&A work, there's a ton of use for contract review. So the classic articling student task of looking for change of control provisions, for writing down consents for a transaction. That's something that we use a lot of technology for. And I always hear stories from senior lawyers of back when they were students, they'd have to go into a boardroom with banker's boxes of contracts, and they'd have to line by line read the materials and then write it down and then go back to their desk and kind of summarize it. And I think that kind of shows just the evolution of using technology in like the corporate transaction sense. And then from like a practice management point, we use something called closing folders, and that's kind of like all the documents are digitally signed and organized, and there's no more physical books of every single thing that's signed on a transaction. And then I know in other groups like litigation, there's things like relativity, so e-discovery, and you kind of say if it's relevant or not. And even just outside of corporate, I think there's things within like open AI tools or like generative AI, like Copilot, and as well, I know ChatGPT, there's different firm use policies. At my firm in particular, we've now accepted that people are using Copilot and ChatGPT, so there's kind of an acknowledgement and now guidelines in terms of how to use it responsibly with client data. And then I think every single tool that's out there, from LexisNexis or every single company that works with lawyers, is now pitching, oh, we have an AI plugin. Now we have Contract Companion, and you can use it in Microsoft Word when you're drafting. And I think now it's become the competitive edge for every single software or tool in my day-to-day practice, and even outside of my practice across other groups, about how we use technology. I think it's very much being adopted. And if we're good at it, I don't know. I would say I'm pretty good at it. I think a lot of my peers are as well. And then it kind of depends on adoption of who is really interested in leveraging the tool. I know I've been on calls with lawyers and they're kind of looking for every single capitalization that's wrong. And I say, we have a software for that. And I don't trust it. So there's a bit of a mixed bag of who's good at it and kind of the success stories of how it works. I would say overall, it does help increase the speed of how you're able to do things and kind of reduce the laborious hours doing things that maybe are probably better spent using your brain in more analytical sense than kind of doing mundane things like flipping through bankers' boxes or manually trying to read things in a PDF. Yeah.
I am very bad at a lot of technology things, and I'm a very reluctant adopter of a lot of AI-powered tools. I think I definitely find it's very helpful to use these tools the same way you'd use Google or to sort of find things quickly. It can certainly automate a lot of tasks that were horrible many years ago, where you would have to spend, forever trying to redact things in certain ways. But I think from a learning opportunity, oftentimes taking the extra time to read the full documents, to go through all of the provisions, to do the research from first principles the way they taught us at the University of Ottawa, pulling secondary sources and really trying to go in depth, is something that is sometimes inconsistent with needing to do things quickly. Certainly charging by the hour, people want you to be very, very efficient. That's incredibly important. But it can be easy to lose some of the nuance, the breadth, the big picture stuff if you're just trying to pull things quickly. So I've been a little bit of a reluctant adopter of certain technologies. I do, however, find that tools like Copilot are actually surprisingly helpful for training tools. So one of the, again, not to continue to shout out University of Ottawa's terrific curriculum and faculty, which everyone here I think knows. But one of the things that was so very important when I was a student was learning how to research effectively, to draft clearly, to make things really, really concise and practical. And so I often use Copilot to help students who maybe send incredibly long emails and need to trim things down, or maybe need to find ways to be a bit more direct or a little bit more thoughtful in how they're tailoring messaging. Sometimes I will use Copilot to say, hey, why don't you run this blurb through Copilot and let's get it shorter, let's get it more crisp. In terms of it actually automating a lot of the work that I do, I think most of my practice now is a lot of the analytical work and is thinking through things as much as I can. So I can't automate that out. I wouldn't want to. It's what I like about the job. But being able to run black lines and not have to do it manually, of course, that's incredibly helpful. That said, I'm probably in the minority. I think a lot of colleagues do want to adopt a lot of these technological tools very, very quickly because they are great and helpful and save time. I like to do things a little bit slower, but there's pros and cons to each of those approaches, I think.
So I think I'm probably more in line with you, where I am good at using technology to a certain extent. So, for example, like use of Microsoft Word or Adobe or running black lines, or, I recently showed someone how to use a split screen. I think I changed their life, something along those lines. When it comes to using Gen AI, I shock a lot of people when I tell them I don't even know how to use ChatGPT. Like, I've never used it before, and part of the reason for that is, particularly in litigation, there has been a lot of admonishment from the courts for lawyers using AI and it hallucinating cases or principles of cases. And I've worked with juniors who have essentially done the same thing, and they say a case stands for this. And I'll be like, oh, that's so great. And then I'll go look at the case and review it and say it actually says the opposite thing, or the case doesn't exist. And I think there is a lot of value in being able to dig in, read the cases, understand it from like a story perspective. So often, for example, even when I'm going up against someone in litigation, if they're citing a bunch of cases, my job is to go through their cases and distinguish them on the facts. And I could be wrong, but I don't think that AI can really do that, or can it? Okay.
I'll agree because, like, a recent example, I was like, do a research task and, you shoot your shot with Copilot and see what sources you can then kind of go from there. And I researched, said, this is all wrong. And I'm like, I'm back to square one. I wasted 5 minutes. Like, the poor client. And I think there's examples, and we're talking about pitfalls of technologies. I don't think it's going to replace the analysis that we have to do. And I use the example in like transactional work of, pulls out the provision, but I still have to review it completely because sometimes it's wrong. And we have, things built in where you can try and teach it. And I've tried to feed this technology 400 different examples of a change of control provision, and it still gets it wrong. And that's just life. I think it makes it faster of like doing things, but the analysis is there, and you still have to do the thinking, and you still have to put it all together of maybe this one part of my assignment or this one part of a deal I've sped up of the administrative summarizing, but I think replacing lawyers, which I think is the big thing that's a fear amongst adopting technology, isn't something that's in the near future, that's for sure.
Yeah, and also like what I was going to say as well is that when it comes to researching, like of course, you know, like use of relativity, I'm very familiar with being able to do Boolean searches. I have had to teach juniors like, well, do you know what Boolean searching is? And they look at me like, what? You know, and then I get asked, how do you find the cases so quickly? Well, I use Boolean searching, like, you know, like on Canly, which is free in Canada, which is awesome. You know, it's a great platform. So being able to do that, I think, is very useful. But again, like, there is a lot of value in being able to take everything, read it, analyze it, and know it from front to back.
Yeah, I think the one incredible use case that a colleague recently shared with me for Copilot and ChatGPT was compiling recent news around certain technology policy issues or, you know, history of legislation or things like that, where you're relying on it sort of like a push notification or a you know, a way of kind of keeping vaguely on top of things. But I think, you know, you also see this when working with juniors. Sometimes folks will give you an answer and you're like, okay, well, how did you get there? And then it's hard to get the remaining pieces. So I think you can kind of use it as a starting point the same way you would a Google search, but then you really need to keep digging deeper.
Yeah, I'll, just very briefly on the litigation side of things, I had a colleague or our assistant, I asked her to search for cases, and the two cases she came back were ChatGPT found, and they were the two cases that I already knew and already had, and her analysis wasn't good. And it's because she put it through ChatGPT. And I didn't want to ream her out because she was very busy, so I haven't talked to her about it yet. But her analytical skills aren't going to get any better if you just throw it in ChatGPT and say, is this what you want? So there are pros and cons to it. But I think as lawyers, if we want to keep our job, we need to keep that power of our analytical skills. Another thing is, so I come at it from a prosecutor perspective. And we heard earlier that technology kind of evolves a little quicker than the law evolves. And it does evolve also quicker than government policy evolves. And so we get frustrated, and especially our international clients who come from countries where they're evolving a lot quicker than Canada's Canadian Intellectual Property Office is evolving. And so they're like, well, this has gone through in 6 other countries. How come your trademarks office can't get this through? And that's because their goods and services manual is still stuck in the early 2000s and doesn't understand technology concepts. And so you're trying to explain this to them and say, you can Google search, and they say, and all the examiners are new too, by the way. They have 105 new examiners. I think a few of them have quit, so maybe they're down to about 98 new examiners. And they're like, well, I'm told I have to read the goods and services manual. And I'm like, you're also told in case law to use your common sense, but they don't read case law, and they also don't read and understand legislation. So then as a lawyer, I'm stuck being frustrated that they're not evolving as quickly as technology. And same with patents. I mean, we're talking about promise doctrine. The patent law can get really frustrated. Promise doctrine, I mean, talking about AstraZeneca. That came from the AstraZeneca case, which is talking about there was technology that was in that case. And anyway, talking about emerging technologies that people don't understand, and then you're trying to tell this patent examiner about this new technology or how it's evolving, and it ends up costing the applicant inordinate sums of money because their concepts haven't evolved as quickly as technology is evolving. So it's interesting.
So a theme here, and certainly AI is obviously everywhere in this conversation. And I would add just one other comment that I've observed, which is there's a generational gap that everybody's figuring out, which is, you know, we have young people who seem to come into a practice and have a feeling of an expectation they're supposed to be using all of these great tools to be doing their job, where there's a real gap in communication amongst firms or more senior lawyers who then realize, oh, you used, you know, whatever AI tool to generate this work product for me. I need disclosure of that so I can do all of these things and make sure at the analytical level that what we're putting out is correct, and you know we're not going to get sued for. So it's another thing that certainly I've observed as well. Flipping the orientation here a little bit. So we've talked a little bit about how technology is shaping practice. How are you as private practitioners shaping technology, or have you shaped technology, and what sort of substantive legal technology problems have you been solving?
Okay, sure. Yeah, okay, I wrote down a lot of examples, so I'm like, where do we start? So I guess really quickly incorporating AI, we had that brief discussion of privacy. So how are we ensuring that privacy laws, copyright laws are respected? So how do we create legally responsible AI? And I'm not saying I'm working on that, but somebody in this room can be if they want to, legally responsible AI. And I know that law firms are trying to use, I mean, I came from a big law firm where a lot of technology was starting to be implemented before I was leaving, which meant it was in shambles. Because when you try to put 3 or 4 different brand new technologies into a big law firm with over 400 people at one time, yeah, things slow down before they speed up. So how do we make sure that they're not crossbreeding with other programs that are outside of our law firm, and then we run into this big confidentiality issue? So there's a big question, but I don't have a solution. That's just a legal puzzle that we're trying to solve. Ensuring access to justice, so balancing in-person versus physical copies, for example, for litigation. There are a lot, judges are becoming a lot more open to the idea of let's do this online, let's do this virtually, and this increases access to justice. As you climb the courts, the Federal Court of Appeal and the Supreme Court of Canada, they're a little more hesitant, I think, on some major issues for it to be virtual. They want it to be in person, just because, I mean, you have the Federal Court of Appeal, you have three judges, and the Supreme Court, you have 7 to 9 judges. Sitting, and I think there is something there to do that in person, but the fact that we have that technology there and we've started, that's a solution or a problem that has started to be solved. And it started up in the 1980s. There was a speech that I read about them talking about virtual courts can be coming to us soon. And I was like, well, 1980s, what? Anyway, and then on my area of expertise, one of the big questions, legal puzzles, is ethics. And ethics is not my area of expertise, but as I get through my answer, you'll see. So emerging technologies allowing for more data collection, the possibility of privacy breaches, more conglomerations of data. You know, AI, it bunches a bunch of data together and then spits it out to you as the user. But where did it get that data? Did it have access, legal access to that data? And this is and does disproportionately affect and violate Indigenous laws and protocols. Indigenous knowledge, cultural expressions, which are already ill protected in Canada. We are working on it, and I have been in contact with this amazing international group of lawyers. They're from all over the world that are trying to work on global policies that can help change this. But anyway, in the moment, without the proper reins and ethic considerations and the ease with which Indigenous knowledge and cultural expressions are misused and misappropriated and infringed, the fast evolving technology with the slow evolving laws and also the slow evolving acknowledgement of Indigenous knowledge and cultural expressions deserving protection means that there's a lot of Indigenous communities, Indigenous people, Indigenous businesses that are really feeling the front of this a lot stronger than other maybe Western businesses and communities. And Indigenous data sovereignty, thank you for someone earlier. I think Indigenous issues have been brought up once today, and I was a little bit surprised it was so late in the game, but I was pretty happy that it was on the government panel. And so anyway, solving this problem isn't easy, and that's legal puzzles that we are working on.
So coming at this from a litigation perspective, I know Mika brought up, for example, different courts that have been open to, for example, virtual appearances, et cetera. The federal court, I think, is particularly during COVID. So COVID was a driving force for this hugely. And so during COVID, the federal court really literally just opened opened its doors virtually. I actually was counsel for Telus and Bell against Roe v. And it was the second virtual trial to be conducted in the federal court with Justice Lafreniere as the judge. And literally we had like a virtual courtroom set up in a boardroom that we used. And I have done several trials in that regard using virtual courtrooms with the federal court in particular. And there's something kind of really neat about it, like as a litigator, I'm just like from a personal experience. I had a partner take offense to this once, but essentially what I said is, you're a cockroach. And he said, what? And there's this famous psychological experiment where they had this glass maze. And what they found was that if you just put a cockroach in the maze and you let it run, it would take X amount of time to go through the maze. But if you filled the glass with other cockroaches viewing the cockroach running, it would go faster. And it's the idea that, you know, if you have someone who is really, really good at something and you have an audience in front of them, they actually excel. So a great example would be sports stars. And when you are in a virtual courtroom and you have tables lining that are not in the camera frame and everybody cheering their litigator on, it makes them actually more, you know, they have an audience now cheering them on, and you see like people in the background go, yeah, that's a good point. You know, we all have to be quiet, but yeah, that's it, you know? And it was something very fantastic to see, you know? And it is true that it's kind of coming back to in person. You can see instances where, for example, there are major bad things that happen, like I am not a cat, which was hilarious. I don't know. Anyway, look up the video. It's hilarious. You know, but so I think even in that context, like being a litigator, trying to enforce that change, and it's also an access to justice issue. You know, if you have people in remote communities who can't necessarily make the trip down, it's a lot easier for them to appear virtually, experts to appear virtually, et cetera. And now we have practice guidelines in the federal court for that and across various courts for that specific reason. So I think that's great. Also, when it comes to evoking change in technology, particularly in IP law, a lot of that is grassroots litigation to force the hand of the legislature. Or sometimes not even, you know, it could be through common law. And there are great examples across IP in general where that has happened. For example, in trademark law, we have the landmark cases of Mattel and Masterpiece. In copyright, CCH, what does it mean for fair use? In patent law, like I said, we have promise doctrine is a great one. We also have the Pfizer case with like the obviousness test and the anticipation test, which is in some ways I would say gone back a bit, depending on what side you're on, with the FCA in what the word construe means. And so there are different ways in which change can be evoked. And the new ones, which I truly do believe are going to be coming up very quickly in litigation, AI, obviously, we've talked about a lot. But what does it mean to be an author? What does it mean to be an inventor? Can you actually attribute this personhood to AI? Currently, the answer is no through the legislation, but can we make a case for it in litigation? And another one, which I don't think a lot of people, particularly if you're not in the patent sphere, would really know about, is method of medical treatment. And I think that that is going to be an issue that will eventually have to be decided by the Supreme Court. There are some pretty good cases which may make their way up. But what does it mean to exercise skill and judgment? And if you have a range of a dosage range, I'm not, sorry, I see Elise in there. When you have a range, does that necessarily exercise skill and judgment from a physician point of view? If you have a dosage day, does that necessarily exercise skill and judgment? And so I really do see that kind of being on the docket when it comes to the way that litigation can actually evoke change in the intellectual property sphere.
I'm saying that's incredible. I know very little about the patent side and pharmaceuticals, so I'm just nodding along, so I think it's fascinating. I think in terms of private practice, I would say majority of what I do in terms of like changing like how technology is used and influencing clients. It's probably from a compliance standpoint. I know you're going to add to this as well. So in large part, I do some work with like the privacy space in terms of like drafting privacy policies. And we're chatting at lunch about startups, and sometimes you have clients and even other businesses, and you're like, you don't have this at all in place, and how do you protect people's information? And I think that's a big part of compliance, is making sure your clients are, following what the requirements are under the legislation and certain considerations. And I think it's always rewarding to be, okay, we started with nothing and now we have something that's very much, you're now on side versus you were offside in terms of meeting the applicable privacy laws. And then I do some work in like the broadcasting space, and I think pushing the envelope in terms of like responding to changes with like regulatory filings and proceedings for the CRTC. I think that's a big part of like my practice as well. And just kind of knowing that lawyers are at the forefront of advocating for certain positions that are going to shape the new media landscape. I think that's really exciting in terms of changing technology. And I'd say internally at my firm, I'm always giving feedback about what the flaws are in the tools. So even if it's not for the clients, I'm trying to fix the tools we have. And that's how I'm part of shaping technology at my firm.
I think I'm going to tackle this question from a slightly different angle, because most of the work that I do is around technology contracting. So usually you've got two sides that want to achieve a particular goal. They kind of know what the end result is, but they're not totally sure how they're going to get there. And they're trying to figure out how to apportion risk and do all the day-to-day stuff. I think a lot of the work that I do on that side of my practice doesn't really feel like lawyering a lot of the time, because a lot of it is just trying to translate between what a lot of different stakeholders want, what they think they know about a particular piece of technology, what value they think that technology is going to add to their organization or their other stakeholders. So I feel like most of what I do on a day-to-day basis is, sometimes it's looking at case law, but not as much as I thought when I was in school. A lot of it is sitting on calls with people and asking, hey, how does this work? Or what, I get that you got a standard form contract that says all of these things, but what is the solution actually intending to do? What are the data flows? Sometimes that can be challenging. It was certainly very challenging for me when I was a junior in my practice, because you I think, face a lot of imposter syndrome, where you don't want to ask the stupid question of like, hey, you've had this precedent for 5 years and everyone knows it, and but I don't know what it means. I think a lot of my day-to-day is asking technical teams, what is it you're trying to achieve? Talking to business stakeholders and say, you can't really do that. But here's another way that you can, achieve a particular goal or reach a particular outcome. And a lot of it is trying to translate between a lot of different stakeholders who often, for lack of a better word, kind of speak a different language about the technology they're trying to adopt. You've got technical folks who feel very strongly about, certain functional requirements or certain encryption standards, but maybe are less, thinking about data flows. And then you've got the legal side in an organization that is very, very thoughtful about data flows, but isn't quite sure how you're going to, meet a certain functional requirement. So as outside counsel, oftentimes I'm on calls just trying to field a lot of questions, ask a lot of silly questions so that other folks don't have to, about, what is it that we're really trying to achieve? How is something going to work? When is the schedule going to happen? And how do we get very practical about what we're trying to achieve so that we can document it in a way that anybody can understand? For work that is more public-facing or work that is for, consumer technology, the test that I use almost every single day is that I've got a 21-year-old brother who is wonderful but does not like reading long documents. And I am constantly thinking about, how do I make things clear and concise and engaging in a way that my brother would want to read it? That means a lot of editing. That means a lot of iteration. That means a lot of trying to take big, complicated subjects and make it as user-friendly, as thoughtful, as pointed, as precise as I can get it. Most of the time that feels like copy editing in 3D. It doesn't feel like I'm certainly not litigating anything. I'm certainly not, drafting the policy briefs, but it's trying to take all of the incredible hard work that other people are doing around me and then document it in a way that, when you give it to someone like my little brother or a judge or many different stakeholders who approach things in very different ways, are we all on the same page? And that can be pretty challenging, but it gives me a lot of, it feels really good when you get it kind of right.
A lot of good examples. It occurred to me just while we were talking here, there's one perspective here that's not represented, but which I would say, if they were here, would be speaking very loudly, and that's plaintiff class action lawyers. And particularly in the privacy space, which is where I work, they are constantly innovating, figuring out new ways to bring cases, not just over hacked companies and breaches, but over commercial practices. That is the current focus of most of the cases, is ordinary commercial practice without, allegedly adequate consent or disclosures, and bringing those things before the courts. You can debate whether this is to line their pockets or is effective at behavior modification. I can certainly say on the defense side, which is where we sit in most of these cases, it does have an impact. Companies do look at the exposures that exist as a result of the litigation cases that are pending, and they do modify their practices. There's no question, because the theoretical liability exposures currently around some of these practices, typically involving technology that push boundaries, are really significant. And so they do have to do that calculus of risk versus, that type of exposure. So just wanted to put in a plug for those plaintiff lawyers who aren't here, but certainly do a lot of really important work in shaping technology law. And we can see it in Canada quite prominently in privacy, for sure. In terms of other stakeholders that we've had at the conference, academia, government, civil society, and then we'll have an industry panel following ours. Which of the groups have you found the most interaction with, or the most effect in terms of impacting the shape of technology policy?
Government, probably, for me, as an IP lawyer. I'm not saying they're shaping technology, but they need to.
Yeah. I would say in private practice, government shapes technology a lot more. But I think personally, I'm like, academia, yes. I missed the literature in school. And I think that's where the crux of all the knowledge comes from in order for government to make the change. It's the academics, doing the research, showing the impact. Like, this is why intervention's needed. This is the type of intervention. So I think it's a mixture of both. And then I think industry is like the player that we typically act for in terms of having to get on board with compliance, or maybe we're advocating don't intervene, that type of position for clients. So it's all different parties I think I interact with in my work, but definitely the biggest impact is government, because I think it very much changes the course that we are on in private practice.
So I'm going to say academia, and one, because of the research which is generated through academia, but also because of the influence that academia has on the legal field as a whole. And, I love teaching and I love storytelling, and that comes together very nicely in a litigation practice, because one of my mottos is all I have to do is teach the judge why I'm right. And that also comes into play when you're interacting with students and when you're mentoring them. And, academia and academics, they have a huge influence on their pupils. And being able to properly train those young lawyers, or those not young, but junior lawyers, and being able to bring them up with a very contextualized view of the world. And, in this context, like I would like even Professor Bailey, I had one of my aha moments in one of her seminar classes, which was cyberfeminism. And it was a seminar class, and there were 20 students in there. The other 19 were there for the feminism, and I was there for the cyber. But it was eye-opening for me, and just being educated in that realm, and really like, wow, like it just totally shifted my view of the world, and being able to move forward with that view, with those convictions. It's a huge part of the reason why I do a lot of Aboriginal law now. And so I really do think that just even those minor influences will really, really, really have amazing effects generations to come. I always say that you are remembered not by what you say, but by the impact you have on others. And I think academia certainly has the most impact on the most number of people.
I jumped in to say government quickly, but the reason why I didn't say academia first is because when I worked in the bigger law firm, which I was kind of forced into because there was the big merger, anyway, so I'd cite people like Jeremy DeBeer and Ian Kerr and Professor Geist and Jane Bailey, and I cite them in copyright cases, in emerging technology law cases. I say, okay, well, here's some really great quotes or minds that we can throw into this factum, and a lot of times the bigger guy on the file, the partner or whatever, would look at it and they know some of you. And so sometimes, and I'm going to say particularly with Jeremy DeBeer and Professor Geist, they'd say, are you sure we want to cite them before the judge? Because sometimes there's some controversial opinions between how a practitioner thinks, I know, right? Between how a practitioner thinks and an academic thinks. And I love being that, like, oh, but these people like influenced my brain and how it works today. And they're like, okay, well, Mika, maybe it was a little too influenced. But then sometimes I snuck you guys in still, okay? Like we still put you before the judge. So you really do influence the legal world. And it's interesting to see the controversy. Sometimes you do have to take them out of the factum because, yeah.
I don't know. Oh, okay. We're at the time where we're going to turn to questions. So if you have questions, think about them. I'm going to ask one more just while you're doing that. So for our panel, we're here celebrating 25 years. For the next 25 years forward, any key lessons that we should carry forward in terms of shaping technology from what we've discussed today?
Sure. I've got a bit of a pet interest in this, but I think really, really focusing on being clear and practical in the type of work that we're trying to do. I mean, you certainly hear this from a lot of practitioners that things come down and folks say, I don't know how to implement this. And I get this from clients all the time, where I really think I'm quite fortunate that most of the clients I work with truly want to do the right thing and want to be, very thoughtful about, avoiding harm and doing what's right and all of that. But I think it's very, very important to both cultivate with the folks you work with, asking the kinds of questions of like, what is this actually practically going to look like? How are we going to implement this? And I get that for a lot of pieces of legislation, it's impossible to have guidance that covers all potential things. It just won't. But most of my day-to-day is trying to find ways to help people who really, really want to. I find especially among Canadian clients, everyone wants to do, privacy by design and default. Folks really want to be quite forward thinking, but finding the right way to sell that message in a way that's practical, that you can sell back to business teams, and in a way that is, very, very simple and kind of plain language, which is so hard because, as a number of panelists have said, these are incredibly complex areas of law and policy. So trying to find ways to make it crisp and clear and something my brother would care about, it's incredibly challenging. But I at least in my day-to-day practice, I'm always trying to think about how do I make this take something really, really big and complicated and iterate on it until I feel like I can speak clearly, confidently, comfortably, in a way that's not too lofty, in a way that's kind of action-oriented.
My suggestion for like a lesson for the last 25 years and looking ahead is mostly related to, I wish more lawyers knew all the stuff us in this room are lucky enough to know. I think it's such a privilege to be so knowledgeable in this space, even just to, take in one course, two course, like whatever the case may be. I really just wish there was more education at the law school level. And then I was fortunate, so I have an undergrad in sociology and I specialized in science and technology studies in my third and fourth year. And I think that was an incredible opportunity in undergrad from a sociology standpoint, just learning more. And I just truly would just advocate for going going forward, technology is something that's just talked about and everyone kind of has a baseline understanding of, what are the fair information principles, like different things that come up, like what is the key consideration when you have Gen AI, and all the things that maybe we are then like the specialists that are punted little things and questions in our practice. Maybe it could be more triage just from day-to-day like interaction with other lawyers and their clients. And I think it would just make the whole space a better place if more lawyers who are at the front, like the forefront or the front line, just more knowledgeable about technology law. And I hope that encourages more courses. If it's mandatory, sorry to add another mandatory course, but it'd be really great if there's more education, especially from the law school standpoint.
Yeah, and recognizing that a lot of these are interdisciplinary conversations that occur between industry, between technical advisors, between lots of different people who take lots of different approaches to common issues. So finding ways to have those conversations in a way where, you set down all the first principles in a way that everyone kind of understands, and we're not relying on jargon or, things that are too, have the concrete conversation.
I think for myself, it would be the lesson for the next 25 years, and I'm piggyback off of Mika's comment, is making sure that there is a very stringent level of ethics when it comes to development of new technology, from something as small as to ensuring that Amazon cannot delete books off of my Kindle, that my iPhone cannot be bricked, right up to, that my personal information will not be disclosed because I had a click-wrap agreement, to, a parent of 9-year-old twins, to ensuring that their identity is not stolen and used online. So I think just making sure that there is a stringent guideline for ethics in developing this technology and having ethical boards or ethical oversight over that kind of development.
So I think, be excited for technology, but approach its use with a critical mind. I think a lot of us in this room have great critical minds, but I think the use of technology is decreasing the ability for students coming up the pipeline to think critically. So think how well this technology affects its users, how it affects others, how it affects the environment, how it affects the health. So in Indigenous practices, they think holistically and they look at the intertwined nature of things. So how does tech, environment, health, human rights, how do they all move together? And Western practices are more siloed. So maybe we can learn from our Indigenous history, from our Indigenous peoples, from our Indigenous communities. So assess critically and holistically, considering future implications before adopting.
Questions? Yes.
Hello, my name is Joanna Thelmai. I'm a second-year student here at the Faculty of Law. My question regards Bill C-2. What do you think are some of the most challenging impacts that this will have for your clients if it were to become law that you will have to navigate them through?
Does anyone know what Bill C-2 is?
Is anybody dealing with Bill C-2? No.
Oh, okay. It's currently in reading, but it has this act called the Assisted Authorized Access to Information Act, which internet service providers will provide information about their customers to authorities to assist them in their investigations, which will kind of bypass warrants in a way when there's critical circumstances. So
I don't want. I am doing work with that. I don't want to hog the panel's time here. So I'll just say a little that it's a very significant and important piece of legislation that not only as individuals we should all be paying close attention to, but I think it's often assumed that this is targeted to telecoms, when in fact it's any provider of any service to the public. So it's law firms, it's accounting firms, it's your bakery, it is extremely sweeping. Where it's going to land, I think, remains to be seen. I think there's probably a lot of lobbying going on, would be my guess right now. But we're in an environment currently where it probably has the best chance of being passed than at any point in recent history. So I think pay attention.
If anything, I can predict that there will be a lot of litigation surrounding it if it is passed. So congratulations all, you have work for the next 20 years. Excellent.
Hi, I'm Katie Salegi. Nice to see you all. Some of you were here this morning for our academic panel. Some of you weren't. Unacceptable. So I want to talk a little bit about generative AI, as I always do. And what worries me when I hear about how law firms are charging ahead into the bold future of using generative AI for practice efficiency and for improving outcomes, right? We're all ruled by the billable hour. We have to do things faster, faster, faster. So as soon as we're able to have things that are going to simplify our lives, we're going to start to rely on them. When I educate people about generative AI, one of the things that I really like to focus on is the statistical aspects of how it works, right? It's not conveying meaning. It is coming up with a statistical approximation of what the next word should be in a series of tokens. Not even words, right? Tokens. Words have been reduced to tokens through a process called tokenization. And people are nonetheless, right, excited about the output because it feels like human communication. It feels like it's developing a narrative, but it isn't able to convey meaning. Now, in Manitoba, the Court of King's Bench said, all right, lawyers, if you're going to use generative AI, you have to disclose that you're using generative AI to assist you in your practice. And so I do a lot of judicial education, and I'm on some committees with these Court of King's Bench judges. Do you want to guess how many people have made a disclosure to the Court of King's Bench? Precisely, right? 0. No one in the entire province of Manitoba has ever used generative AI in their legal practice. I know. Do we find this believable, right?
Absolutely.
I am very worried about what it means for the conveyance of meaning, right? For our deeper humanity, for what it means to participate in a world-building exercise like law and the rule of law when we start to rely on these tools. Have we thought about these issues in private practice? How are we seeing them emerge? Does anyone care, or are we just saving as many minutes as we can for the client?
I care so much. I think it's really challenging from a training perspective. So I see a lot of juniors who are trying to manage so many things all at once and impress all the partners and impress the associates too, I guess, wanting to do things that they think are better quality because they're informed by what ChatGPT spit out. But to your point, absolutely, it is it is associative. It is things that have been said in the past. You're not getting as much thoughtful insight, I think. You're not getting people who remember what they've told you or what they've read. I think it's going to be really, really challenging in training junior lawyers. Folks trying to manage the efficiency gains, sure. Like, I don't even find it that much more efficient. I'm maybe in a bit of a privileged position because I've been doing it a little bit longer, but I find even when I do start with a ChatGPT prompt or whatever, I end up redoing a lot of the work and you end up spending more time. All that to say, I'll turn it over to the panel, but it's going to be a huge issue and it's going to be really hard for training new lawyers.
Well, often as the token queer on things, no, I was being facetious there. Yes, of course I care. I think fundamentally what it comes down to is training, and this goes to your point. Training juniors specifically that simply because you receive a piece of information, you should not automatically accept it as right. And that is not necessarily, that's not restricted to AI.
Oh, yeah.
That is, I have been burned many times by people where I'm busy and I'm just like, oh, they did this research and they said this. Like as a junior, I was burned like that. And those lessons you never forget. So sometimes it takes admonishment from a judge. Sometimes it takes admonishment from a senior partner. Sometimes, it takes gentle training. Like you can't just do this like that. It depends on how people learn and how people remember things. I know, for example, like in the federal court, with the practice guidelines with this. So they didn't originally. I don't know what it is right now. Originally, it wasn't restricted to generative AI. It was restricted to AI. And what people forgot was like if I run spell check through my Word, now I'm using AI. And so like it went the other way where everyone was disclosing that they used AI. And so I think, of course, like there's a huge concern there. I know from a private practice standpoint, I can tell you from big firms in Toronto, they're all extraordinarily concerned about it. Like it's not something that is being taken lightly and that they're just all worried about the billable hour. If anything, and I would say like the impetus really does come to juniors, where just really training it out of them, the reliance on the AI, specifically when it comes to like, for example, like I think litigation and actually virtually everything, like as we were talking about, Yeah, you have to, right down to the everything else, like you have to make sure that what it is displaying is correct, as opposed to it's just a quick and fast way to do it. It would be just like if I'm asked to summarize a case and I Google it and I lift a summary off of someone's website. Like, how do I know that's right? I don't. Like, I have to actually do the work to make sure.
Yeah, it depends on if the people in Manitoba, I don't know if they're being trained by younger lawyers who also like AI and can't tell the difference now between if they're just using AI and not using AI. So they all are just like, research is research. And also the provincial courts are regulated differently than the federal courts. And so my experience in the federal court is it's very, very deeply considered. And we have like in the firm that in the firm that I just came from, they had a policy, an AI policy, and we had to all talk about AI. So I'm shocked that in Manitoba they're so far behind that someone's like she said, if you're doing spell check, AI is being used. So I'd have a longer answer as well, but we're told to wrap up, so I can't.
Yes. One last, since you're already standing, Jason. Thanks.
Great. Awesome. Actually, before I ask the question, I want to tell a little story about Alex. And I can't think of a better audience than this to tell this story. So as Alex mentioned, I was, or I am, I guess, one of the OG graduates of the CLTS. Marina's nodding, I can say that. I was a contemporary of Alex. And he mentioned that one of the most important areas of law back then in 2003 was the question about how copyright applied to file sharing. And what Alex didn't mention was that he was involved in arguing the seminal case on that in Canada at the time, BMG Canada and Doe. And I was also privileged enough to be part of the group that put together those arguments. And the four of us, Howard Knopf, Pippa Lawson, who was then executive director of SIPC, Alex, and myself, went down to Toronto with our big boxes of paper documents. And we get down to Union Station, and I generously offered to carry Alex's box. I took that outside. We were organizing taxis. I put the box in the back of a taxi, and then Howard Knopf proceeds to get into an argument with the driver. The driver gets upset and drives off with Alex's oral arguments and all of his supporting material in the back of the taxi. And of course, it wasn't an Uber. We couldn't figure out, Uber didn't even exist back then. We couldn't figure out where that went. Alex had to spend the remaining hours before his arguments the next morning in federal court recreating his oral arguments. I felt terrible, as you can imagine. Alex was a gentleman about it. He said, "Don't worry about it, Jason." But I've felt terrible for 22 years.
Howard's not here, is he? We can blame Howard.
I just want to say publicly I'm sorry. But I also want to say that over the past 22 years, whenever I've found myself in an awkward, uncomfortable position, I've thought about Alex and how he had to recreate his oral arguments for the federal court. By the way, he won. So congratulations on that.
Thank you, Jason. Very kind. Thank you.
And my question very quickly is, we're talking about AI and how AI affects legal practice. Are you seeing that it is affecting hiring policies now or the need for baby lawyers? And when we think about what the next 25 years might bring, what does that look like? What does that mean for schools like this?
Hiring is decreasing. Number of students big firms are taking on is decreasing.
My experience in the recruitment on Bay Street is that currently it's not in play. With regards, for example, if someone comes in with, for example, technological experience, that might be like a plus, but it's not as though firms are specifically seeking out those types of individuals.
I agree. And lunch, we're chatting about how you can't teach the tech in school. I can't explain to someone how to compile signatures and closing folders in 2L. It's something you kind of learn on the job. I think all of the software and systems are also firm specific. So I don't think it's trickled down to the hiring decision. I think it's still very much the same process of, do they have enough general skills to be good at the analysis of doing the job? Not, can they use the tools instead of doing the analysis to do the job? I think the skills is still the emphasis for hiring.
Thank you, panel. Amazing. Thank you all for sticking around. Wonderful job.